Going live. Welcome to the show tonight, everybody. We are here and it's time to have some fun because that's what we do. We're starting in tonight. Welcome to Advocates for Justice Paralegal School. I provide the tools, you guys do the work. I'm Coach Neighbors, and tonight we're going to review the conventional strategy for defending against the HIPAA violation. And we're going to talk about a few other things. I'm going to review my non-conventional strategy so you can decide which strategy will provide you with the best value to make the third-party debt collectors go sit down. Because remember, that's what our goal here is, not to have the judge rule in your favor or none of that, because I haven't seen that happen anywhere. And this is why we do the non-conventional program. Now, first, I want to cover a few facts that you must use when you're communicating with these people. And I'm talking about the court clerk. Anybody on the other side that you're communicating with, if they feel like you don't know what you're talking about, they will let the other people know. They all put their heads together to try to figure out a way to smash you. I can say that. My people in the corner are looking okay. So they moved around over here a little bit more so I could see them better. I don't know why they do that, but we're doing good. The third-party debt collector's complaint, and this is what I'm about to share with you, is what you need to smash them. So if you're already in this situation in court and you're about to get pushed off the edge of the cliff, these are the things that you need to know to attack their document, their fraudulent document. Okay, so you guys listen up on this. So third-party debt collector's complaint is usually pled as a account states. And this cause of action requires a couple of things. It requires proof, one, of a prior transaction that establishes a creditor relationship between the two parties. It also requires proof of an expressed or implied agreement between the parties as to the amount due. And they are required to prove an express or implied promise from the debtor to pay the amount due. Now, if they were going to do things the way things are supposed to be done, they would provide all of these things in the court. They would provide the original contract that you signed, and the other party signed. They would provide an accounting of the money trail or whatever it was that they gave you, and providing all those things would be a problem because these people bought the debt for pennies on the dollar, and they're not worried about proving anything because they know that 99, probably 99, maybe 100% of us now can't afford attorneys. So they're going to go with the odds. The odds are they're going to get what they want because you don't know what to do. And some of the people that are here watching that have some idea of what should be getting done, they are sitting and waiting. They want to know how many wins and all of this stuff, and I'm like, okay, so what you got a better plan? What's your plan? Because usually people who are asking me how many wins do not have a plan. And if they did have a plan, I that's working better than mine, I sure want to know about it so I can start changing some things. So I'm still waiting for that. That's a challenge. Now, if you guys are coming from Facebook, please go to this link going across the bottom of the screen and grant StreamYard permission to use your Facebook name. Otherwise, you just show as Facebook user when you leave a comment. So we want to make sure that you guys go ahead and do that so we can know who's making comments and you can take the credit for it, especially if it's something good. or bad. Yeah, we go either way. So let's just keep rolling here. So the third-party debt collector will have issues proving the following. So you should focus on them. And these are the things that you want to focus on. If you're already in court, then you want to file another response. Or actually, what we don't respond to them. What we do, we just file a lawsuit and we include all this stuff in it. Now you can do a counterclaim in their state case, so you don't have to pay and mess that up. But at the end of the day, the way we have been getting control of the situation is by filing in federal court and taking all of their stuff over to federal court. You have the documents to remove that and everything over there. So let's go over a few things that they're going to have trouble proving. Well, they can't prove. Okay, it's not trouble. They can't prove. And they can't prove the following. They can't prove account states. It's not proven. They can't prove account states in what they filed in court. They cannot prove that they have standing. They cannot prove they have a assignment. And that's a huge thing. There's no assignment. They cannot prove that they have assignment. And without an assignment from the lender, alleged lender, saying they have the right to do this stuff, if they don't pay, they got crapola for the programmer. I'm just saying. Now, this is an important one they cannot prove. They can't prove damages. So if they can't prove damages, the court doesn't have jurisdiction to do squat. Check. The damages or injured party is what gives the court jurisdiction to act. Without being able to prove damages, they can't prove that there was any harm done to anybody. So they have no witness. Oh, wait. They have an affidavit that says that they attested to the records. Well, what records? They didn't attest to the right records. Yeah, well, you can't cross-examine the stinking records. So no, objection, Your Honor. I don't know why I'm objecting, but I'm objecting, and I'll figure this scam out a little. Okay, you might want to use some different words. And the other thing is, in most cases, the statute of limitation has run out. And I usually do that anyway and just make them prove. They can't prove none of the other stuff we already talked about. So whether the statute of limitations is up or not is irrelevant. And I have a lot of people that pick, oh, well, dude, get your stuff filed. Don't worry about dotting all of this stuff if you're about to get pushed off the edge of the cliff. If you're facing a summary judgment, you need to get your stuff filed and not worry about having it notarized if you can't get it notarized. And there's another tip I want to tell you guys too while I'm on this. You need to make sure you pay to file your lawsuit because they will dismiss it if you file form of paupers, fill out those papers or whatever. Yeah, they're going to throw your stuff to the curb. They will throw the stuff to the curb that you get from me for any reason they can that they can get away with doing it for. That's I'm just saying. So you can say you got a right to do whatever, and while you're arguing that, they're going to be speed up the process and throw your stuff out in the street. So I'm just saying, I've seen it a whole bunch of times. And when you guys get in my program, you got to remember that my program is structured off of the feedback from a whole bunch of different people and a bunch of different Facebook pages. So, you don't need to call me and ask me if you can add stupid stuff to it, because if you needed to add any of that stuff, I would have had it already in there. So you need to remember that you're on a non-conventional program now, and you're not doing the regular, the conventional program. And you cannot use my documents in the conventional manner. I've had a couple of people do that, and they wonder why they're getting dismissed and kicked out of court. You cannot use them in a conventional manner. And we never wait on the judge to answer nothing because we're suing the judge. I mean, if you haven't figured that out by now, you're behind. We're suing the judge. We're not waiting on the judge to rule on nothing because the judge is already helping them by allowing this crap to go forward without an injured party or damaged property or without anybody being approved they were damaged. So there you go with that. This stuff that you're learning here today and that you learn on the website and on my YouTube channel and stuff, this stuff is the stuff that you want to get up in their face long before any court dates are scheduled. Now, before we go any further, I want to do the thing. I need you guys to make sure you subscribe to my channel, ring that bell so you get notifications when it's time to rock and roll. And also make sure that you leave a comment, hit the like button, and share my stuff if you respect what we're doing and feel like we're bringing value to the table. And here's a link to the medical debt dispute letter that we're talking about. Now, I have this on my website connected. I have the checkout connected and everything. I don't have the information in the product page yet, and I hope to get that in the next day or two, get that set up. We've been getting things done with just a one guy show so we can keep our prices low enough to where people can afford them. So that's what we're trying to get done. Well, that's what we're getting done because we're affordable and people are in the program. Now, let's just get started a little bit. We're going to talk about, let's review the conventional strategy for defending against a HIPAA violation. Now, I studied several YouTube creators' videos on this subject in the last couple of days. Because I wanted to see what other people are doing and see how it compares to what the coach is saying that you guys should be doing. So that's what we're going to get into right now, and it's real interesting. And I think that you're going to find a lot of value in this. So let's get rolling. And I'm going to tell you, you guys are doing you're doing the right thing. You need to keep doing what you're doing, and you need to add just a few of my bombs in the mix there to get control of the situation. And I say that because if you weren't a fighter, you wouldn't be listening here. You wouldn't be here listening to me or checking out my videos or even thinking about, can I say it now? Okay. Punching some attorney in the face. Literally. I mean, not literally. So if you're watching this and you're taking notes, then you're a fighter and you're in the right place. If you think that I cuss too much or that whatever, you don't like the way I talk or my coaching or I'm too whatever, that's fine. Hit the thing and move on. But please subscribe and ring the bell before you leave. Please. Okay, sorry. Okay, sorry, I got carried away on that one. Yeah, if you don't like it here, just go ahead and leave. You don't have to send me comments, negative, nasty comments, because I'm not going anyplace. We're here to get something done, and we're in the process of getting it done. And I know there's a lot of people out there that don't like what we're doing. And for those people, I could just tell you, don't get in the way. Now, the conventional program against HIPAA is demanding a debt validation letter. And everybody tells you the debt validation letter. And all of these people that I watch in the videos, that's what they say you should start out with. The debt validation letter, so you can get them to mail you incriminating documents. Let me see, it takes these people, I don't know, forever to get it. And then by the time they figure out they're going to mail something, it'd be another couple of weeks past. I'm thinking, how is that time frame fitting in with your situation? Most people, it is not fitting in. I wonder why they have it set up that way. You think there'd be a faster way. Okay, no, we'll get to that. So in their conventional program, you'll be sending letters back and forth while they're taking your money if you're already at the point of the attorneys attacking your wages or your bank account. The system their attorneys structured for you to follow The system the attorney structured was for you to file a worthless complaint with the CFPB. And now the illegal debt collectors will get a free pass because they dropped the case against you. Once they see you know what's up and you're about to be a pain in their butt, they drop the case against you. And then, and then they sell your debt to their buddy attorney down the street so they can come after you again. Can I get an amen? Somebody tell me that ain't true. That is what's going on. I see it. I see it from talking. That is what's going on right now. And when they structured the program that you are on, the program for you to follow, when I said they, I'm talking about the attorneys, when the bar members structured the program for you to be on, they did not have a provision to hold the attorney engaged in illegal debt collection liable in federal court or any court. And I'm just going to say, if I was structuring a program for you to follow, and I was the one that was attacking you to take your stuff, I would want to make sure that when you got to the end of that path, that you're not kicking my ass. I'm just saying. That's so, I mean, if you could structure the program, you structure it the same way. That'd be like the coach calling the play. Who's going to draw a play on the board to show your people and then have the X's kicking your butt if you're the O's? Don't work like that. So I'm watching this. So everybody's following the path and sending out the debt validation letters and taking forever to do this. Well, they're giving the illegal debt collectors a free pass to keep. Can I say it now? I can say it now. To keep punching you in the face. They're getting a free pass to keep punching you in the face. On the same hand, if you structure a pass for me to follow, just like I said, and I'm the one violating your rights, I'm going to make sure at the end of that pass, you're not kicking my butt. That's if I'm the one drawing it up, that's the way it's going to be. That, my friend, is the difference between my non-conventional program and their conventional program they structured for you to follow. In my non-conventional HIPAA offensive strategy, you will be sending the attorney your notice of claim to start the 30-day countdown to allow them to correct whatever is the problem. Now, if you're already about to get kicked off or they're about to take your stuff, or you ain't got time for no notice of claim, you just need to file your lawsuit against them in federal court and get that puppy rolling, get it on the records and get rolling and get control of the situation. And what I also tell people to do is, before you move to federal court, you have to get control of the state court process. And that's really what I'm talking about here. A lot of people get it mixed up and they think that, I haven't talked about the traffic tickets or haven't talked about some particular. No, it all doesn't matter what we're talking about, because in my program, we're not going to the table to respond to the lies that they stated. So what you're learning here is how to control the court process. That's what you learn, how to control the court process. So instead of sending a debt validation letter, and you will be lining yourself up to sue them at the gate and bypassing the Consumer Financial Protection Bureau, because they're not going to help you do anything. They're not going to help you get compensated. They're not going to help you get these people to sit the hell down and leave you alone. They're not going to do any of that. So I'm just telling you, I've not seen that, and I've been doing this for a long minute. Now, you have the right to fight, and you all must do it. You must continue doing what you're doing. You just need to change a couple of things and start fighting with the new weapons that I'm putting together, so you can start learning how to have some fun. Now I'm going to do a screen share And then I'm going to show you guys the inside of the HIPAA package. There we go. So this is what you look. This is what the package looks like. Well, actually, this is what the package looks like when you open it up. It'll come to you in a zip file, and you open it up. And I'm thinking about adding 1 or 2 more documents in here. I added the sanction motion here, which is like a second lawsuit. It's like a mini lawsuit inside of the lawsuit. And I added it here to help you control any processes that's going on in court already. And I think you're gonna find it very handy. We're gonna start out with the notice of claim. Oops, it opened up. Now, this is in a letter format. So what you're going to need to do is you're going to need to copy and paste it into a letterhead off from your computer. So I just put it in a Word format so you can copy and paste it in a letterhead from your computer. Now this highlights some of the most important stuff in the lawsuit, and this is included. Now you'd want to use this if you have plenty of time. If you're to the point where they're already trying to take your money, then I probably wouldn't use this. I had one guy telling me, well, I'm going to do both. Well, I wouldn't do both because when you send them the letter, then they have 30 days to sit around and do nothing. So, and if you don't give them 30 days, they're going to complain. They're going to complain about any little thing they can when you're kicking their butt with some fire. Now, like I said, if you're already in the middle of this process and they're trying to throw you off over the edge of the cliff, don't worry about this. Get your lawsuit filed in their face. This notice of claim letter, notice of claim, they don't have to respond to. The notice of claim is basically to punch them in the face, give them a chance to go, sit down and let them see what you're going to be bringing to the table. But if there's no table and you're on the edge of the cliff, you don't have time for this. You need to get to the point. And I also have people, a lot of times people will get the state citizenship package, and then they'll wonder if they should hold up and follow everything. No, the state citizenship package is not mentioned in the instructional video to be filed at any particular time. It's stuff that you use later down the road. Right now, until you get that lawsuit, until you get the state court process stopped and your lawsuit filed in federal court, you're exposed. I can say that, right? Okay. You're exposed. Now we're going to look at the first page of the actual lawsuit document so you guys can see. Here we go, and open up here. So we'll move it down. Okay. So this is the lawsuit package, the lawsuit that I put together for the package. I studied quite a bit about all of these fancy words, so that I can make sure that we are pleading them in the lawsuit. So, and it was a while ago that I studied all of this. So, if you want, and I'm just going to show you down the first page, you can see how this works. You have to replace the red font with information from your situation. That's how this works. Welcome to the program tonight. Welcome. So we're just gonna scroll on down the second page. And then you can see the facts of the dispute. So this is a pretty serious document, and right now it's undefeated. If you follow the stinking instructional video. Now I added this document in, and I'm going to make a few changes to it tonight to personalize it more for the HIPAA. But it's the motion for sanctions. They're under Rule 11, they're supposed to do a reasonable pre-filing investigation, and they never do. So instead of just asking for silly sanctions, we're asking for what they would be asking for, right? Some money. So you got 3.5 million in sanctions. And the idea is to put yourself in a position to force a judge to have to rule on this stuff. And then as soon as the judge helps them, then you sue the judge in your federal lawsuit. We got it all wrapped up nice and neat. Now we'll be taking this part out because, like I said, I'm going to make changes to this. We're just going to take out the criminal stuff and get right down to the pre-filing investigation. I changed this to help someone. So we're going to change it back, take the criminal stuff out, and just leave it the way we need it. So that's the sanction motion that we've added today. And I like this one. This is one of my favorite ones. Well, the sanction is one of my favorite ones too, because the attorneys like start whining. Like little sissies. Okay. So you're demanding to strike the attorney's notice of appearance from the record because the corporation cannot represent itself in court. And I'm pretty sure this is in all of my packages, but people don't go through the package and read the documents and understand them like they should, or this would be the first thing that I would be filing too. And then when the judge tries to help them, then you want to sue the judge. So you want to set the judge up to need to help them, and then you want to spank the judge for helping them. I mean, excuse me, and then you want to address the judge violating your due process by helping them. Yeah, that's better. And yeah, that rule is pretty pretty wrapped tight. So the judge is going to have to let them go and violate the rules, or the judge is going to have to give back his or her cut that they got from helping them steal your property. That's my take on the situation. And last but not least, I include this in all of my packages, the affidavit of whatever your name is, Jane Doe or John Doe. And I like to include this in all the documents because if they don't argue by counter affidavit, they're in default. And they can't because they can't sign for someone because there's no injured party. Oh, everything back to that injured party thing. Now, if getting this signed, if you don't, somebody call me, they didn't have their driver license or whatever, they couldn't get the, don't sign it. I would leave it in there because I would want them to know that that it's in there or whatever. But if it's stopping you from getting your stuff filed to get control, then I would not sign it. I would go ahead and I would not have it notarized. I would go ahead and sign everything and then and get it filed because until you get it filed, until you start stopping some stuff and get control of some stuff, you're exposed. So that's just I'm just gonna leave it at that. Now I'm going to Now I'm going to share with you guys what the package looks like on my website. And I have it marked at $300. It's on sale right now. And I need to go in and put the description and some things in here about it. I'll get that done in the next couple of days. But it's already connected to checkout. So if you're interested in this, you can click on the checkout button and the add to cart button, and the file will be emailed to your email address connected to your payment method, and you will be able to open it up and get started. So that's how that works. Okay, we're back. We're back to business. Now, I have this lawsuit package that you just seen posted on my website. So you guys can go there, winningcourtnow.com, and check it out if you're interested in it. Or if you can also email me email me, send me an email requesting the HIPAA package, and I'll send you a link to it so that you can check it out. Now, I want to take a minute before I go to explain to you guys why my conventional legal strategies will forever change the landscape for foreclosure offense, or actually for legal offense, actually, because it's not just for foreclosure. And the number one reason why my program is fire is because it's affordable. It's affordable. I work very hard to make my documents affordable for the average family. There's not too many other places you can go and get for $400 to $600. Get what you need to control the court and have a chance to fight. Not very many places you can go and do that, and there aren't very many places. Well, there aren't any places you can go now and enroll in a foreclosure offensive online course that's structured for entrepreneurs and paralegals. It's also structured for property investors to use to protect their real investments. And the property investors would be able to hire people to take the online course, and they would be setting up their own foreclosure offensive team in-house to handle the foreclosures. And think about it, if somebody wanted to get serious about that, you could also rent your team out when they get done taking care of all your business. Yeah, we thinking all the time up in here. I think the second best benefit that you're going to get from being in my program is the fact that you will learn how to stop the attorneys yourself. You will learn how to stop the attorneys yourself. And you will do this with no attorneys in your way. Well, no attorney that you're paying in your way. There will be an attorney in your way that you're going to be smashing in the face, that you're going to be jamming up in court. There you go. That's better. But not one that you're paying. And that's just going to throw you under the bus in the end. So you're going to be filing a lawsuit against the attorney who signed to start the foreclosure. That's one. You're going to be going after the attorney who signed to start the foreclosure, the one that's been up in your face and telling you that the lender don't want to work with you, or that they will work with you to stall you and lying every time their mouth's open. Yep. And in my program, we're going to teach you how to smash the judge when the judge helps the attorneys. We have a provision in place for that. And most people don't. Most people are going to go appeal. Well, we're not going to waste our time doing that. We got some lawsuits to file. And people always are worried about their stuff, if they can do it. And I'll tell you right now, people are worried about if they can do it and if they have enough money to pay. Well, you don't have to pay someone to mess up your case. You can mess up your case all by you. Yeah, I'm just saying. You can mess up your case all by yourself. Okay, so I'm not making my point here in the right direction, but actually I am. And what you need to remember is, and my program is structured for you to sue the people who signed to start the dispute without an injured party or damaged property. And that's anybody. Anybody who signed on to there is who you're going to be suing. The judge name is on there, the attorney, the prosecutor, whatever it is that you're in. That's how this program works. So you don't really have to worry about messing up the case yourself if you follow instructional videos or contact your coach. I'm the coach. If you invest in one of my programs and you have questions that aren't covered in the instructional video, you can friend me on Facebook and send me a message in Messenger, and I'll get back to you when I can. So don't send me a message and then call me. Okay. It doesn't work that well. I have a lot of people I'm helping, and this is the program that I have to have set up. And that's how this works. So send me a message in Messenger, and I'll get to you, or you can email me. Now, the email's a lot slower because I don't do a bunch of emails during the middle of the day or whatever. So with that being said, the best way to do this is to send me the message in Messenger, like asked. That's the best way. And I'm going to tell you right now, the biggest thing that you can do, if you're doing this already, the biggest thing that you can do to change your situation is check and see who the number one defendant is. If you have the lender listed as the number one defendant on your lawsuit, you're done. You're doomed. Okay. Because the lender's signature is nowhere on the document that was used to initiate the foreclosure process against your property. Go check if you don't believe me. That's the biggest mistake most people make. You change that and you add the judge, you add the stinking attorney to your lawsuit. And remember, you're adding the judge and the attorney, the judge to it, because there's no injured party and the judge doesn't have jurisdiction without injured party or damaged property. So there you go. Once you do those two things, you're going to mess up their case ASAP. You're going to mess it up real good. And think about it. When you sue the judge on a state court level, no other state court judges can hear the case. And they would have conflict of interest. So now, and what we did in my sister's case, we moved her stuff over to federal court. So you can do that same thing with their credit card lawsuit. You can move it right over to federal court and just get in the interest of justice. Because once you sue the judge, they can't leave it in state court. So you can file your counterclaim in their stuff and then move it over to federal court. That's if you had time and you just want to punch them in the face. So, and the reason I come up with this kind of stuff is, so I'm going to tell you a little short story. When I was in college, or right after I got out of college, I boxed. And so I went to the gym, and there was a trainer in the gym that he actually worked with Muhammad Ali, real old dude. And he was training me to do this stuff. And I was in the Golden Gloves for a little while. I was actually trained to get in the Tough Man contest, but I trained in the Golden Gloves so I could get some practice, because it was hard to find someone big, like me to, so anyway. So I'm training, and we go to our first match, and our first boxing match. And there was somebody for me to box. I was so excited. And my coach told me, I need you to knock this bum out. And I looked at him, I was like, dude, I'm not going to knock him out. And my coach was like, what the hell's your problem, neighbors? Oh, why? And all the other guys like, what? You knock him? No. I said, I'm not going to knock him out. And coach like, neighbors, what the hell's your problem? I was like, coach, you have no idea how much crap I put up with from you for the last 4 or 5 weeks. He put 2 or 3 people in the ring to beat up on me, and he had me outside chasing rabbits. I'm not lying. Yeah, he had me doing all this crazy crap. So I told him that I am going to enjoy beating this dude in the face. And he's going to have to give up. I'm not going to knock him out. He's going to have to give up, and walk away. And that's the attitude that I have in stuff that I do. Okay. I'm not looking for no judge to rule on none of my stuff because you're suing the damn judge. Okay. What we do is we keep punching them in the face until they go sit the hell down. Because I tell you right now, to win, people ask me how many wins. Well, you mean is the judge going to give you something? Well, that shit ain't going to happen. Okay, judge is not going to give. I'll just say, judge is not going to give you anything. I haven't seen that happen yet. So that's kind of what my program is about. It's about punching them in the face until they go sit down and leave you alone. And like in my sister's case, it's going on 3 years now. But I don't, I can't tell you how long it's going to take, but what I can tell you is I'll provide you with what you need to keep punching them in the face as long as they want to play. Now, I want you guys to leave me a comment about what you think about my work. And if you've looked at my packages or invested in one of my packages, email me a Google review and I'll post it on my website so other people can see it. And I'm going to mention it one more time. The package is on my winningcourtnow.com website. I put the link in here so you guys can see it. And I'm also going to post a link to my oops, that's not the wrong one, to my website here. So let's get back to the program here and get this wrapped up. Let's see here. So if you guys are facing this problem, you need to get over to the website and no, Tom, I'm pretty sure I'm not a girl. I would be a pretty big one. I would be big enough to kick your butt more. Okay, never mind. Hello, Edith. How's things going with you? So that's all the value that I have shared with you guys tonight. I want to thank you for the privilege of sharing your time, and I will see you guys in the next video.